Hi, everybody, and welcome to our webinar. While we wait for a few more folks to join, why don't I spend just a couple of minutes introducing myself and my partner, Lisa Bivens, as well as today's topic, litigation with legal intelligence. For those of you who don't already know who we are and what Darrow does, Lisa and I are partners at Bivens PLLC, and we work closely with Darrow AI, who is generous enough to have us on their webinar series today. Darrow is a legal intelligence company that helps plaintiffs' attorneys detect and litigate impactful cases, mostly in the class action and mass tort space. Bivens serves as co-counsel to essentially all the plaintiffs' firms that work with Darrow. I joined Bivens at the start of 2026. After spending a couple of years at Debevoise and Plimpton and Patterson Belknap in New York City, I also clerked in the Federal District Court for the District of New Jersey. Lisa, why don't you introduce yourself, give us a little bit about your background, and add anything else about Bivens and Darrow that I haven't already mentioned.
Yeah, great. Thanks, Max. Really glad to be here today talking about this exciting subject. I've been litigating in Arizona for about 10 years now. I've got experience in commercial litigation, civil rights actions, class actions, regulatory litigation. I've been on both the defense side and the plaintiff side throughout the course of my career. But my heart is really in this consumer protection work, which is what I love so much about partnering with Darrow, because it allows us to really scale the impact that we're having as plaintiffs' attorneys.
Thanks, Lisa. So let's get to the heart of our conversation with what I'll call a table setting question. What is a data-originated case?
All right. So a data-originated case or a data-driven case, it means that as a plaintiff's attorney, you're not waiting for, a client or a plaintiff to show up on your doorstep with a case in hand saying, this is what I need help with. Instead, it means that we're using technology tools to first identify the plaintiffs and the causes of actions and to go out and find that hard evidence to support those lawsuits. So plaintiffs' attorneys know that a lot of claims are essentially invisible to the naked eye, especially in the area of privacy violations, consumer protections, ERISA cases. People don't know that they're being taken advantage of because it's not being advertised to them. So oftentimes cases are really dependent on someone figuring it out. But data-driven cases let attorneys issue spot in a deeper way and sooner. The technology helps us look behind the scenes to get a sense of what is happening to people so that we can spot the potential misconduct that's otherwise hidden from view and then bring those cases once we've already found them.
And one thing just building on that's been surprising to me after joining Bivens is really the huge impact that origination theory has on the way that we litigate. Rather than waiting for discovery to really have the piece of evidence that we need, we can have it in hand before we go in. And Lisa, why don't you give an example or two of that? And I'm happy to talk about some too.
Yeah, absolutely. Right, like you mentioned, usually attorneys are doing this in a different order. We're relying on the discovery process to find our best evidence. That's hours of time crafting the right discovery request with the exact right questions to capture what we hope is going to be the bulk of evidence, where we can start doing that doc review and digging, looking for that smoking gun. Data-driven cases flip that script. The starting point for us is often the smoking gun itself, which data helped us find. So for example, we have cases, privacy violation cases, where we can see the HTML code that captured and disclosed personally identifying information from websites that had a duty to protect it. And this is particularly concerning in the spaces like healthcare and financial planning, where consumers are entering their sensitive personal information with the hopes that they're going to find help and trusting that the institutions that they're giving this information to are going to protect it. And they're not realizing that their information is being sold for commercial gain. But with the data-driven approach, we can see that HTML code being captured, being disclosed. And so we have that smoking gun in hand before we ever start. Max, where else have you seen this in our work?
Yeah, I love that analogy of the smoking gun. One other example that, it's complicated in technology, but is very simple to explain that we've been experimenting recently with Darrow-derived cases are consumer protection cases about, basically it's a false advertising theory, but where companies will say that a product is on sale. They'll claim that sale is for a limited time. It's a $1,000 product, but for the next 48 hours, it's only $500. That makes consumers want to jump at the sale. The psychology shows this. And it's good for sales. That's why companies do it. But what we find is a lot of the time, the products were never actually at that full price. They're just making up a full price, making up a sale discount. And sometimes they'll change it by $1 or $2 to make it a little harder to detect. But it's never actually been at that full price, or at least for a predominant amount of the time, it's not been at that full price. So in the state of California, there's a consumer protection law. It says essentially you can't do that. If you're going to advertise a sale, you have to actually have a real price and then have it marked down from that real price if you're going to advertise it as such. And what we've found is it's very hard for consumers to detect that kind of violation by hand or by the human eye. You know, could somebody scroll through a website with thousands of products every day and check the price and write it down? Maybe, and maybe those products will be the ones that are always on sale. Could they go to a store and look at the price tag every day? Maybe, but not at a big scale, and it takes a huge amount of time and resources. What we can do is using the technology that Dara has, using AI agents in mass, we can scroll through tons of websites, look at every product every day, or at least a huge portion of products, and then see, okay, how many days has this been on sale? Has it ever been at what's called the struck through price, the price they advertise the full price? And if so, for how long? And if it never has, and it's a made up sale and it's a consumer violation, we can then go find the people that are injured by that and make sure that, the company knows that the law is enforced and that people, get the return that they're supposed to, or the recovery rather. So, kind of bringing that home and building more onto how that really impacts us day to day as the litigators that are often bringing these cases as co-counsel. What are the implications of all this for you, Lisa? How does it help us recover on behalf of the plaintiffs, on behalf of the classes that we represent?
Yeah, great question, Max. I think that it really does change the game for litigators to be able to have this approach and the data in hand. And some of the ways that I've seen that change just how we practice law when we're bringing these cases is that, like we already mentioned, you're coming in strong with your evidence. You're not really relying on that discovery process to prove your case or to figure out the strength of your claims. The data-driven approach allows us to stress test the evidence before we're ever bringing a claim, so that we already know, what the strength of our case is going to look like, what areas of vulnerabilities we might have. We're able to see those vulnerabilities play out in other cases. So, for instance, because we're bringing so many of these similar causes of actions, we're able to track, common arguments for motions to dismiss. We're going to find those barriers, develop ways around them. We also get to have this holistic view of the litigation life cycle. We get to see track settlement values, figure out, what are these cases worth? How much do they cost to litigate? And what does a good settlement value look like, so that we can identify, what is a push point? So when we're, trying to advocate for our clients, when do we push? When do we lay down our swords? And really just trying to bring some sort of method to the madness of strategy, because so often in litigation, you're feeling it out as you go, trying to get a sense. There's a lot to be said in the plaintiff's work of, them trying to out-litigate each other, outlast each other, and having this approach allows us to kind of see all that stuff coming and to really understand what we're signing up for at the front end, because we already know what evidence we've got. We know the claims we're going to bring, and we've seen it play out in different jurisdictions over and over again. It also is very helpful to us in the mediation context, trying to convince our clients, opposing counsel, their insurers, what a reasonable settlement looks like. Because when we can point to these, these data points of this is why we think it's worth this much, we think that this is what these cases are settling for in other jurisdiction, that really helps us bring some meaningfulness to those conversations, rather than just a game of bracketing and trying to see who outlasts each other on the playing field. So it takes a lot of the guesswork out of strategy planning. Max, what else did I miss?
I think you covered it. What I think it boils down to is really having a data-driven approach to litigation. That's something that has been missing in litigation, I think, for a long time. But if you can back up your claims, like Lisa said, with a mediator and say, no, in fact, the market for these settlements are X. And when we come in with this evidence, what we think it's worth based on a reasonable view is X plus 10 because we have this smoking gun, because we have this red flag, because we don't need to wait for discovery and we don't need to spend $1 million doing depositions because we already know what the HTML code shows, which is the violation, going back to the example that Lisa, said earlier. So it really just brings, I think, gravitas and, helps you convince opponents, neutrals, plaintiffs and ourselves to check ourselves and also to support what we might think initially is the right move. What does the data show, and how does that drive the case forward and drive the best results for our clients? Lisa, anything else to add to that?
Yeah, I think the only other thing that comes to mind is that, a lot of the stuff we're dealing with in these data-driven cases are themselves, tied to ever-developing technologies. What can we do with code? What can we do with analytics and trackers? And what can websites accomplish by, asking people to add their information in? What can websites, companies do to have auto-generated sales and all of the different technology systems that are driving business that are up and coming. It allows us to kind of peel back the layer of understanding and go, well, what is really happening here, and get our arms around that while it's happening in real time. So it allows us to kind of keep up with those developments and try to protect consumers at the same pace that the technology is developing to find all these ways to violate their rights. And intentionally, unintentionally, we're able to keep track of it and figure out what's going on so that we can step in and help make sure that the misconduct is kept in check.
Mm-hmm. And that reminds me of something you had said, actually, when we were talking about this webinar in advance, which is often in these class action cases, you have kind of a David versus Goliath situation where the single plaintiff and the plaintiff's firm, which has a lot less funding than, for instance, a major technology company, a lot less technical know-how in how to get into the weeds on the code base and what that all means in terms of the legal implications of it. All of a sudden, you have these, engineers and data scientists, when you get to work with Darrow, that make David a big, scary David for Goliath, and make that fight, even though it worked out well for David in the real story or original story, but, put people on a more even playing field and really try to get relief and make sure that the outcome of the case is just and not a result of an imbalance in resources, as it can be. And especially, I think plaintiffs' firms suffer from that often just because of the imbalance that's inherent to it.
Yeah, I mean, that's just, you just hit the nail on the head. There's so much risk involved as a plaintiff's attorney, especially bringing, larger cases. You really have to feel the confidence in your case to move forward. And the data-driven approach just gives attorneys that confidence to know what they're signing up for and to know that they're going to make a meaningful impact. It just takes all that guesswork out. And like you mentioned, just levels that playing field. So, Max, I would love to know if, in your experience, you've had any particular examples that come to mind about how you've seen this data-driven approach really change just the process in litigation. Anything that jumps out at you that you'd like to share?
Sure. So why don't I give a specific example from the mediation context, because we've been speaking about that a little bit. And I'm going to leave everything very broad and the numbers made up, of course. But, we were stuck with an opposing party back and forth with a settlement value that just was not going to do it. For us, from our perspective, it was not near what the case was worth. And we and the defense counsel were hugely apart. And what finally broke through, actually, was disclosing to the mediator that we've done a lot of these cases, that we've done them across the country, and that the final value, honestly, ends up being X. And we're absolutely not willing to go to X and don't tell the other side what X is yet. But Mr. Mediator, you need to understand that that is the range that our brain is in, not in the world that defense counsel's living in. And to that point, not in the world that the mediator was really living in. So, of course, it's mediation, and one could always walk away. but we were there. We had paid for the mediator, and it was worth it to take a little risk to disclose maybe more information than one otherwise might, but because it could come from a place of experience, because we had, another mediation scheduled the next day on the same type of case, five more with the same, co-counsel firm in the last 2 months, and many more coming up in the future months. The things that are said in mediation from the Bivens firm and from the co-counsel that we work with are paid attention to and treated with respect, as a matter of course.
What did the mediator do with that information to help kind of move the needle?
I wasn't privy to what he said to the other
Right.
side, but I will say that it went from I think what they would call a nuisance value settlement to
Mhm.
what we considered a very good faith um, offer that we were kind of looking to get from the beginning. And just by how long the mediator had been with the other side, reading between the lines a little bit, it sounds like maybe he earned his keep in that position and made sure the other side absolutely understood where we were coming from.
Yeah, great. Sometimes that extra little information can help really nudge things in the right direction. I know we've been talking a lot about kind of the differences at the beginning of the case, starting with that smoking gun in hand instead of having to dig for it, and then, all the way towards settlement discussions when you're trying to really, put an objective value on a case. What about in between? Have you seen any ways in which this data-driven approach and partnering with Darrow helps plaintiff attorneys, through that workflow process along the way? Like, how does it change that part of the process as well?
Yeah, I think there's two main points I would want to make sure I cover. One is making sure we understand who the class is, and two, having a hands-on, non-testifying technical expert to help litigate along the way. So the first being, because the case is generated through this data-driven approach, when we're trying to figure out who's the group of people that were injured by this, we can take that information up front and scope, for instance, where we might want to run advertisements. What's the geographic region? Where are people tied together? What ties them together from a data driven approach in ways to be efficient about driving advertising, which is a big cost for plaintiffs' firms? The second is along the way, kind of going back to that David versus Goliath analogy earlier, it's having a technical expert really help along the way without billing by the hour to the plaintiff's firm, without racking up costs, to really explain at every level in a way that's understandable to the court and understandable to technical people why this is a violation, what's occurred, what's the likely scope, and why the motion to dismiss should be denied, the motion for summary judgment should be denied. This piece of discovery is relevant because of this technical connection that I might not know, but because we have those Darrow folks, working closely with us and on the phone with us all the time, we can uncover. Lisa, does that ring true to you? Anything to add?
Yeah, definitely. And it reminds me of one of the things that I've seen play out is that, you know, often during the life of the litigation, when attorneys are trying to, really hone in on what's the best way to tell this story and what's the best evidence to present in a way that's really compelling and, captures kind of what the heart of the issue is. And so you're always thinking about what's the way to make this as crystal clear. And what I have seen is that plaintiffs' attorneys are often able to work with Darrow to help them, unpack it a little bit, explain it a little better, walk us through exactly what this would look like from the consumer's perspective, and also, see if we can find other examples, right? These are the examples that are really speaking to us. We'd like to see if we can go find some more, and having that expertise right there to help, build the case as you go, so that they're not just there at the beginning saying, here's your smoking gun, but here, let's go find five more like it because we really think that this is the most compelling piece of this story. I have found that is something that's very useful for litigators because, litigators are out there advocating, setting up the claims, showing how this is, the conduct is not aligning with the requirements, but really having those experts to help us fill in the blanks and explain some of these more nuanced issues is really helpful. That's really what comes to mind for me.
Yeah, and you reminded me of one more point that I wanted to drill into before we skip to the Q&A. I want to save a couple minutes for questions. So just very quickly, we've talked about being able to drive deeper into a case to understand the tech, but also having Darrow be involved throughout the case has helped us look horizontally too. So if there's a violation going on one website, are there other websites that have similar issues going on? And can we look across an industry to find a much broader range of violations in a way that, if a plaintiff comes to a plaintiff's attorney and says, I have this problem, it would be harder to do kind of at scale. And then, of course, there are efficiencies in bringing the same type of case with the same type of violation. We learn a lot. Drafting is easier. We've done a lot of the research and going from there. So before we run out of time, though, I just want to jump into a few of the questions I see we've gotten in. So the first one is, you spoke about some of the consumer protection cases and some of the privacy cases. What other types of cases do you litigate with Darrow? Lisa, do you want to give one other example and I'll give another?
Yes. So some of the cases that I like, we've talked about the privacy violations ones. We also see these ERISA cases that are in the context of, I think this is fascinating, the fiduciary duty to make sure that people are minding their investment opportunities. And a lot of the times, with those 401ks, the people that are members of those groups and benefiting from them have no idea what's going on with the management of their investments, with the administrative costs. They have no idea if they're getting a fair deal. There's a lot of trust involved. And so a lot of our cases focus in on making sure that those funds are being well managed and really pointing out where they're not, because people are being taken for a ride, but they would have no way to know without kind of this holistic approach to what's going on here. What else?
Yeah, so another area I know Darrow's looking into that I'm really excited about are these greenwashing cases. So there's been a lot of these over the years where you make claims about environmental attributes of a product. They turn out not to be true and people bring suit, and there's been differing levels of success with that. But what Darrow's really doing is bringing that, data-driven approach again, where they're doing stuff like using satellite images of rainforests and other places that are claiming to do carbon offsets. They're going out into the field and testing soil. They're testing air quality. And that kind of start with the big data, but willing to invest along with plaintiffs' firms into more intensive research into what types of violations there are, especially in an area where, look, lying about how environmentally friendly your product is a serious consumer violation. So those types of cases coming down the pike, I'm really excited about. Okay, we have another question in the chat. It's what can a plaintiff's firm expect from a co-counsel arrangement with Bivens? So Don Bivens PLLC currently has 3 partners, Lisa, myself, and Don Bivens himself. Don's an extremely experienced plaintiff side litigator and also mediator and defense litigator. And each firm that takes on Darrow cases is going to have a Bivens partner that works hand in hand with them on all their cases, whether you have 1 or 50. So because you'll have one personal contact, you're going to have one person who you can pick up the phone and call and chat about the case, chat about strategy, is going to be with you on the brief writing, is going to be looking over the amended or the pleadings, the complaint, an amended complaint if necessary. But you also are going to get the combined experience of all the Bivens lawyers. Lisa, Don, and I talk every day, usually multiple times a day. We talk about all the cases we have all the time. We're also each in contact with Darrow folks working on each case all the time. And that way you get, both an individualized treatment and people, with knowledge of your specific cases, but you get that holistic view that Bivens brings because we're on all the Darrow cases across a huge spectrum of jurisdictions, huge spectrum of class actions and mass torts. So we can bring experience from not just the cases I'm on, but also the cases Lisa's on, and then Don bridging that gap, overseeing the whole thing. And to our point earlier, you get that technical bridge of plaintiff's firm co-counsel who's experienced litigating the cases, but also on a daily basis is interacting with the tech side of Darrow to really translate to the jury, translate to judges, and do the best we can for our clients, which is obviously the most important thing. So I think we have time for one more fun one, and then we have to go. So Lisa, what is your favorite thing about working with Darrow?
My favorite thing about working with Darrow, and I'm happy to take the easy one, is that I think it's just really exciting to be a part of the way that technology and artificial intelligence are developing and helping the legal field expand and do better. A lot of what the focus on for AI and tech in the law world is focused on helping attorneys with their processes, go faster, research faster, write faster, put it together faster. And this is different. This is about, doing a better job of finding causes of action, of figuring out who is there to help and what kind of help do they need. As plaintiffs attorneys, this is really just taking all of the stress out of that needle in the haystack, approach of really having to find the case. The cases now, there's so many cases that we need all these partnerships. We need that we need all these hands to help because it's just a lot to do, and that feels good. So that's my favorite part. Max, you have one?
Oh man. I mean, just the difference from coming from a traditional kind of big law shop to working with tech forward people who are looking to get to how do we help the client at the end of the day with whatever resources we have and being creative about it, and the ability of different teams that I can see on the Darrow end lending a hand whenever their expertise best serves the ultimate client is just really, fun to be a part of. So that's all the time we have today. Thank you so much for joining us. We hope you found it interesting. If you'd like to work with us or Darrow on cases or talk about any of the things we discussed today, please get in touch with Darrow at contact@darrow.ai, or feel free to reach out to Lisa or I can be reached at max@donbivens.com, and Lisa is lisa@donbivens.com. Thanks so much, everybody.
Thank you.